through the economic sector to get something done in surveillance cases. Because in these mass surveillance cases, we typically have a private actor and a government actor. The private actor is collecting all the data and the government is plugging in the back more or less. And kind of having this public-private partnership in a way, we have the benefit of actually having jurisdiction in the European Union over the private part of it. So that was kind of the basic idea of the case. The whole thing then went to the Irish Data Protection Commissioner, who found that my legal arguments that were apparently frivolous and vexatious, and therefore they didn't deal with it. The High Court was rather quick in Ireland as well, because there was a judge that was politically very wise, but legally kind of kicked out all the Irish law issues. He could have kind of already decided on the Irish law, but he kind of didn't address them at all. They were kind of even not in a judgment, and kind of said there's only a European Union law question anymore, and I send it off to Luxembourg, which politically was a wise decision. Legally, you can question it. And it was interesting because we got the case up to Luxembourg in almost no time. So we did the round trip in, I think, 2 or 3 years, something like that, which was really kind of interesting. And the situation was really this hot potato issue that they just wanted to kick it out and off it as quickly as possible. So my big concern at the time was the question that was posted by the Irish court was very generic because of Irish law issues. And I was afraid that the court wouldn't address the core matter. Because they could have easily kind of stepped to the side and, give some answer that didn't really address the core issue. And luckily they did. We got the written questions from the court before the hearing, and that was the point where I felt we won it, because after data retention, there's no way they can say that all this is legal in a way. So that was probably the history there. What's happening now, the Irish Data Protection Authority is investigating Facebook again. They have done what they called substantial submissions and submitted that in Ireland on the 20th of December, I think. I haven't seen them so far because the Irish DPA is not good in sharing documents. Basically, it doesn't. And they said it's substantial there, so very likely Facebook just spanned them with 1,000 submissions. What was interesting, we got 2 letters from the Irish DPC from the 2013, so back when I filed initially, where Facebook actually never argued safe harbor. I thought that was really interesting. They argued standard contractual clauses back then, but the Irish DPC didn't tell us. So we actually walked to Luxembourg and only found out a year later that this was never a matter in the core question. The Irish DPC decided not to share the document, so we didn't really know that Facebook was not even arguing safe harbor, which is, I think, a very interesting twist for probably the community here, which, yeah. We will have a couple of new cases probably on the other data, on the other people that were involved in the Prism scandal. I pretty much have them on my laptop for a month now. I didn't submit them so far. However, I'm now waiting what's going to come up next week with the kind of new safe harbor. One thing I also want to say is, for me, this whole case was never a kind of anti-US case. It was always an anti-mass surveillance case. So I hope it also has a huge impact on European surveillance systems, which, of course, was not that much reported. Another thing that I would like to address is a lot of the lobbying that came out of the US last week, where basically they say we pick the weakest European country and say we're essentially equivalent to the weakest European country, so everything's fine. So if you're like essentially equivalent to the UK, it's all fine and good, which I thought was interesting, because as being essentially equivalent to the UK is no price you typically want to win in national surveillance questions. And they totally missed that there are 2 jurisdictions, that there's a European Union jurisdiction which follows, where you have to follow the Charter, and then you have national member states that do a lot of things wrong that we can probably talk about like right now, which is 2 different issues, and I think that's something I wanted to address on like looking forward. And then we're going to see what we see on Monday or Tuesday.
So thank you very much for the opening. This panel is about the implications of the Max Schrems case for law and policy. And we have organized the panel so that there will be perspectives from various jurisdictions, including the US and important European countries. Also, I would like to introduce into the discussion certain conceptual or substantive questions which relate to the question, what are the implications? What the Schrems decision means for surveillance law and policy in the US and Europe. And I would do it in the form of 5 items, 5 points. The first issue is whether intrusion into privacy starts with a human being processing our data, or whether it's a mere access, even hypothetical access by authorities into data. And the ruling by the European Court of Justice confirms the latter. Mere access, mere potential of access constitutes an intrusion into our privacy. Then it's a question, what dimension of privacy is affected and how deeply it is affected. But intrusion starts right there. This may explain why in that ruling, in the Max Schrems case and some other cases, the role of the separate autonomous fundamental right to data protection appears to be fading away. I don't think it's fading away. Privacy has taken a bigger role because mere access affects privacy, whereas data protection rights come into picture at a later stage. So I think we are now looking for the proper space where data protection issues arise. Second point is the fiction, the division between content and metadata. Those who deal with these issues know that it's a fiction. Nevertheless, the European Court of Justice decided to maintain that fiction. Law is a very useful tool in, fictions are a very useful tool in law. For instance, the state is a fiction. Human beings are not. They are real, but the state already is a fiction, and so is the division between content and metadata. It's important to note that in the Max Schrems case, the European Court of Justice decided an intrusion into the essence or core of privacy because it was about content data. You can get the same result of unlawfulness also going through particularly serious interference, as the same court decided in Digital Rights Ireland, but it was on different grounds. When you go through particularly serious interference, you in principle end up with a proportionality analysis, so to say, balancing. Whereas if you go through the core approach of the essence of privacy, in principle, you don't need to balance. The answer is already there. You have intruded into the core. That's a no-go area. Third point is whether mass surveillance now is the way of intruding into the essence of privacy. And I think there's strong grounds, both from the EU Court and from the European Court of Human Rights, to say that yes, indeed, that's a no-go line, a red line. One then has to ask, how do you do the targeting? If you do the targeting through electronic surveillance, you are back in mass surveillance, because access is already a form of surveillance and intrusion into privacy. There has to be other methods of doing the targeting than starting from electronic surveillance. Fourth point, the Max Schrems case, of course, relates to transfer of commercial business information, and that's within the scope of EU law. Much of what is done in surveillance is in the field of national security, which is in the scope of national sovereignty, that is member states of the EU, and hence technically not affected and possibly much harder to get to the EU court. That said, privacy applies also in the field of national security. And if we think that the European Court of Justice has been able to clarify the scope and content and essence of privacy, that would affect all laws also in the field of national security, but it would be for the European Court of Human Rights to do the international monitoring and control of those limits. That's why the Sakharov and Szabo cases are so important. They show the way. By and large, the European Court of Human Rights is following the approach of the EU Court, but they haven't really said anything about the essence or the core of privacy. Finally, about oversight. That court, the European Court of Human Rights, appears to go the way that judicial oversight, ex-ante oversight, authorization, is becoming a crucial element in making surveillance legal, if any. I think this needs to be addressed. Certainly the judiciary must have a role, but it's a little bit of a double-edged sword, since when you involve the judiciary in issues where you don't really provide for a full trial with proper adversarial procedures, you may up compromising the independence of the judiciary and the role of the judiciary in protecting fundamental rights. So I hope the panelists will shed light to this, and we move to the round of based on different national jurisdictions, but also addressing at least some of these questions.
Do you want me to go first?
Sarah
Sure.
Vincent will be first, and she will be addressing both issues of US law and UK.
That's right, although I will be brief on the US and even briefer on the UK. Can we get the slideshow started? Thank you. So yes, as Martin so kindly said, I'm going to talk about the implications of the safe harbor judgment for US and UK surveillance in a very, very condensed form. I just want to say briefly, I work for the Center for Democracy and Technology. We work to promote human rights online as well as offline, and although our headquarters is in Washington, D.C., we also have a presence in Brussels and are very active in getting involved in European Court of Human Rights cases and EU law issues. So to get into the substance, in the United States, surveillance that takes place partly or wholly outside of the United States is covered by two main legal authorities. I'm only going to talk about one of them today, which is Section 702 of the Foreign Intelligence Surveillance Act, or FISA. Unfortunately, Section 702 doesn't have a catchy or easy to remember name, so I'm just going to call it 702. The other authority, Executive Order 12333, is also very broad, affects very, very large numbers of people outside the United States. But I think we in the privacy community in the US are still untangling how we think the safe harbor judgment might apply to 12333. I'm not going to talk about that today. I'm just going to stick to 702. So what is 702? I really had to work to cut down this slide because it's a very, very complicated piece of law, both as printed on the page and also in practice. In theory, 702 surveillance is targeted. The target of the surveillance must not be a U.S. person. It must be what the government calls a non-U.S. person. I don't like that term myself, but that's the term that's used. A U.S. person is a U.S. citizen, lawful permanent resident, or corporation. So a non-US person would be anyone or any entity that doesn't fall into one of those categories and must be outside of the United States. The surveillance can be done as long as a significant purpose, note not the only purpose, nor even the primary purpose of the surveillance, is to acquire foreign intelligence information. I'm not going to get into the details of what foreign intelligence information includes. Suffice to say, it is very broad. It can include any information that relates to the conduct of the foreign affairs of the United States. And so it is quite expansive. The government has to adopt what are called targeting and minimization procedures that are meant to protect US persons, so US citizens, lawful permanent residents, anybody else who's inside the United States. These procedures are the only things that the FISA court, the special court that looks at the surveillance, reviews. The FISA court does not look at individual decisions as to whom the NSA targets. It's only reviewing these procedures that are designed to protect US persons. So if the NSA decides that it's going to use a selector designed to target Angela Merkel, there is no court that reviews that specific decision. One key thing to note here, and I think this will help to explain why some of us, such as myself, portray these programs as not targeted and others do portray them as targeted, particularly in the government. According to US government, the act of gathering the data, just gathering the data, is acquisition. Collection, according to the government, only occurs when the NSA or some other entity goes into the data to pick what they want, to select what they actually want to look at or render intelligible, for example, by decrypting it. So when people say that collection under FISA is targeted, by collection they mean the looking for the thing. They don't mean the actual gathering of the stuff, which is actually very, very vast. Whoops, I hit the wrong button. So there are two main programs that Edward Snowden revealed that take place under Section 702 of FISA. They're very well known these days. I think Upstream is actually the easiest to understand. Upstream involves, as far as we understand, the US government compelling service providers to let them effectively sit on the wire to monitor virtually all internet traffic that passes over the fiber optic cables that pass between the US and other countries. So this is an enormous amount of data that's either being copied or split or otherwise kind of acquired and scanned, if only temporarily or briefly. So that data can later be searched using selectors, and it creates this pool of data from which law enforcement can also can search. Prism is maybe more famous. I think it's actually a little bit, it's more detailed, it's a little bit harder to understand. Prism occurs where the NSA goes to companies with a selector and says, give us everything you've got on this selector. And it could be an email address, it could be a name, it could be a number of things. The companies have the ability to push back to some extent in the FISA court about the overall program under which that takes place. They can't fight, as far as I know, about an individual selector. And so, although it is true that some initial coverage of this erroneously suggested that the NSA could just go directly to company servers, and that's not exactly what happens. The effect is much the same because the companies don't have a choice. They have to turn over whatever they're asked to turn over. And this can be emails, it can be Skype video calls, it can be chats, instant messages, it can be a great deal of stuff. There is something called Presidential Policy Directive 28. PPD 28 was issued by President Obama in early 2014. It is a policy, it is not a law, it is not enforceable. Some people in the community think that it is an advance because it does place some very broadly termed restrictions on what the intelligence community can do. Others think that the loopholes are really quite large and that since it's not enforceable, it's not a great safeguard. I would just stress that it's not a law, it is a policy, and that's going to become important when we talk about the implications of the judgment. I want to move on to talk about just a couple of key passages from the judgment and how I think they would apply to surveillance in the United States. The judgment, I know there's been a lot of debate about essentially equivalent, and essentially equivalent to what? What does that mean? And I'm puzzled by the debate about that because I think the court is actually very clear. It tells you essentially equivalent not to what the member states individually do, not to the member states' legal orders, but to the standards that are guaranteed within the EU by virtue of Directive 9546, read in the light of the Charter. So it's the protections that are applied in abstracto in the EU legal order under that directive and under the Charter. That's my reading. Those protections have to be effective in practice, the judgment tells us. So not just there in theory, but effective in practice. Review of this has to be strict, among other things. So limitations on the right in this third country system, so the United States system, for example, has to be restrained to what is strictly necessary. And you can think about the impact this might have on a program like Upstream that is capturing virtually everything that passes over the internet cables. We're also concerned that there are objective criteria that are used to limit the access of the public authorities to that pool of data, and also its use. And the use has to be for specific restricted purposes that are basically justifiable. As someone has just alluded to, access on a generalized basis to the content. I don't know if we know exactly what access means in this context, whether it's the original gathering of the stuff or the looking at the stuff. I suspect it's the gathering of the stuff. Access on a generalized basis to content compromises the essence of the right, and so basically would not be permitted under these charter standards. And then finally, the individual has to have the ability, and again, this has to be effective in practice, to have legal remedies in order to get access to the data and, importantly, to obtain erasure or correction of the data. So those are the standards, those are the requirements that I see the safe harbor judgment as imposing. And so what does this mean for the US programs and laws that I just described? Well, it's actually second on the slide. I think Upstream cannot be compatible with this. I would define it as generalized access to content. It's the accumulation of a vast amount of content and the searching of that without adequate limitations or safeguards. Prism, similarly, I think we would argue that the limitations and safeguards are not adequate. The remedies, people whose data has been transferred from the EU to the US have no effective individual means of challenging this before a court. Although in theory there might be mechanisms, the reality is that it is virtually impossible to prove standing in a US court. Even if you did, you get struck under state secrets doctrine. You can't get into the FISA court because you just don't have the ability to do that. And so individuals are basically left with no effective means of redress, and that doesn't satisfy the judgment, in my view. There's also no requirement that the data be obtained for purposes that are sufficiently restricted. We know that the NSA, CIA, and FBI can query the accumulated data, more or less it will. We don't know what the querying policies are, they haven't been released, but there's not sufficient restriction on law enforcement and CIA access to the data, among other things, and we do know that these data wind up being used in criminal prosecutions. And then finally, there's no requirement that the data be used for purposes that are sufficiently specific and restricted. I'm going to move on to talk about the UK very, very quickly. The draft investigatory powers bill, as others were pointing out in the panel, 2 panels before this one, is an enormous and complex piece of legislation. It does have the virtue of being apparently fairly comprehensive, not always entirely clear. But to boil this down to 30 seconds, it confers very broad powers, including very broad bulk powers to acquire content, to acquire communications data, and also to conduct bulk equipment interference. I think we're all still untangling exactly what that might mean. All of these activities could potentially take place indefinitely, could affect vast numbers of people, both within and outside the UK. And again, I would say, without adequate safeguards. It purports to put in place a system of judicial commissioners, but it's not at all clear whether those judges will be reviewing the evidence and reviewing the merits. And in fact, many of us think that they might not be. There are also issues about independence of the commissioners and so on and so forth. So I would say that Schrems also has strong implications for the UK, which leads me to one of Martin's questions about the EU's competence here, and this is my last slide. I am not an expert on the EU's areas of competence, so take this for what it's worth. But I would say that in the UK bill, these are explicitly mixed purpose programs. They're not just for national security. They are for preventing serious crime. They're for dealing in some cases with tax issues. There are a variety of purposes for which the bill says they can be conducted, not just national security. And so I think we need to ask ourselves whether the government can exempt itself from EU oversight just by not just throwing national, but putting national security in there. There is also a line of cases where the court has said that even where a situation involves an issue of national defense, the EU may still have the ability to legislate and to restrict that. It's a line of cases such as Creel and Sirdar, where the court was looking at allegations of gender discrimination in member states' militaries. And so again, I think what we see here is I don't think a member state can just exempt itself from the restrictions of EU law by saying this is national security, especially if it's a mixed purpose program. And then finally, I think we could say that these programs exceed what is strictly necessary to protect national security. They are very, very vast programs and very intrusive programs. And I think the court may find that it has competence to determine whether or not that is strictly restricted. And anybody out there with greater expertise in EU competence than I have is welcome to challenge that. The last thing I would say, just because I was asked to mention, well, I think we were all asked to comment briefly on the European Court of Human Rights decisions. I do think that we ought to be paying attention to what the Zakharov and Savo cases said about the need for surveillance to be A, individualized, and B, not just relevant, but vital to an individual investigation. I think that we all know those standards basically wind up translating over to EU law because of Article 52.3 of the Charter, and so we ought to be watching that space as well.
Oh, thank you, Sarah, for guiding us through the FISA 702 jungle and checking it against the criteria of the court developed in the Schrems case. I think that's an important task, and also for the brief overview of UK law, and also for clarifying what the essentially, or to what the essentially equivalent criteria actually applies and to what it doesn't apply. I think that this is not necessarily clear to all persons. I think we continue with Stefan Heumann about the German situation.
Yeah, thank you, Franziska. And I would like to say a quick thank you to Jens Jeppesen from CDT, who was crucial to bring about this panel. I won't go into as much detail as Sarah just did. I would like to use my comments to put the safe harbor discussion that has been happening here all conference long into context of the debate in Germany. And to do that, I would like to first take a little bit of a step back. And yesterday was actually really interesting for the debate in Germany. As most of you are probably aware of, we have a parliamentary inquiry committee in Germany that's called the NSA Inquiry Committee, that was charged with investigating mass surveillance of German citizens by the NSA, and in due course of its examination has also turned a lot of its attention to the German government and also to the German Foreign Intelligence Service BND. And so yesterday in its hearing, there was a high-ranking German official from the German Foreign Ministry, because there has been also quite some controversy about the no spy negotiations. And he said yesterday in that committee hearing, he reported how he went, or German officials went several times to Washington, after the Snowden revelations broke in 2013, when this was making the headlines every day in the news. German officials flew over to Washington and tried to engage U.S. counterparts on the surveillance issue, and they were met pretty cold. They were told, that's what he testified yesterday, that Germans shouldn't be surprised. This is, of course we do this for our national security. This is our national interest. We don't really discuss that with anyone. And they felt, they were turned down. And in the fall of 2013, we of course had the attempts by the German government to negotiate a no spy, and whatever you think about that, it never led anywhere. But it also showed that it was really difficult to get the U.S. engaged on these issues. Of course, this changed a little bit in the German-U.S. perspective after in November 2013, the news broke that Chancellor Merkel had been a target of NSA surveillance, and the U.S. government still didn't felt that was legitimate, not just targeting Merkel, but also the broader surveillance programs. And the response was more embarrassment about it, that this was leaked to the public, but it felt that it needed now to engage Germany. I mean, Germany was the debate was pretty robust, and the German public pretty upset, and German politicians now also getting pretty upset. And so what they negotiated, the German foreign minister went to Washington and again raised this issue with John Kerry, and what was said, okay, we're going to have a German-US transatlantic cyber dialogue. And that took place in Berlin in 2014. And again, this was a high-level dialogue with a high-level delegation from the US coming, and what was talked about was kind of big data and privacy, but not NSA and not surveillance, really again on the issue that everybody wanted to talk about. No real engagement. The transatlantic cyber dialogue was widely dismissed in the media as a failure because it didn't address what people felt needed to be addressed. And actually, since then, the German and the US side have not been able to schedule, as was initially planned, a follow-up of the transatlantic cyber dialogue in Washington. So really hard between, on the political side, between the German government and the US government to actually talk about surveillance and what was happening here. And then, of course, we have the Schrems case, and many people have nearly forgotten that actually in the summer of 2015, my feeling was that on the company side and also on the government side, people were like, let's move beyond this Snowden thing. Things. We are beyond this. There's no more need to address this. We are tired of this debate about surveillance, and of course there were now also lots of security issues in Europe that changed the debates. In Paris, most prominently. And so in the summer, nobody and very few people actually predicted or thought it was possible that the European Court would actually issue the decision to invalidate safe harbor. So that's where we just stood 6 months ago. And now you look at this conference. You look at the engagement from the US side, how many US government officials are present here, how many reports on US programs have been published recently, how much has been pointed out again of the activities that, that I do acknowledge that have happened in the US, the presidential review group, the P Club and all that. Now we have, suddenly we're starting to having this robust debate, and I think the safe harbor issue obviously has forced that, and I think in some way you can interpret the ruling in a way as the judges forcing to having that kind of transatlantic dialogue that has not happened in the past. So that's, I think, one of the big significances also for the for the debate in Germany, now that there's a much more robust engagement transatlantically on these issues. And I would like to conclude with a few thoughts on how that is helpful as we are moving forward. Because as was pointed out on this panel, and as Max also said in his introduction, is he wants to challenge mass surveillance. This is not about anti-US or Europe versus US. This is about privacy versus surveillance. And there's obviously a lot of, as was mentioned across lots of panels here, there's lots of work still to be done in Europe as well. But now, 2 years on, and with the safe harbor discussion, we have so much more to go on. There's so much more transparency on these issues. As Sarah mentioned, the UK has pressured to pass a law to become more transparent about surveillance powers, and the same thing is happening in Germany. In Germany, in the course of the inquiry committee by the parliament, found that the laws were outdated, that actually the surveillance of foreign communications and telecommunications is not explicitly authorized by German law, and so now there's a need that from the intelligence community in Germany, there's also been seen that we need a legal reform. And of course, in this legal reform, we also have a discussion now about improving oversight, improving transparency, what should be the authorization process. And For us, really, what we have been focusing on in our work, and that also is relevant to the Schrems case, is what I call the discrimination problem. That in every country, most safeguards regarding foreign intelligence collection only apply to their own citizens. That holds true of the United States and holds true of European countries. And interesting for us in the German discussion is now there's one of the ruling government parties, the Social Democrats, have published a position paper on this, and the German Chancellery is also now working on a proposal how to reform the law, and there is supposed to be a European no spy element in this. So currently what we are discussing in Germany is whether we will extend protections, privacy protections that we have for German citizens across the EU, and as well outlaw within that proposal spying on EU member countries. I think that's an important aspect that can help to also drive the inner European debate forward, as European countries within the EU are spying on each other. And also all the reports and that have come out of the US on what's possible in terms of transparency out of the services, more transparency on the FISA courts. We would like to see much more transparency, as my colleague Thorsten said this morning, on how the G10 Commission works, how the oversight, the legal frameworks that are modernized and the norms for oversight are all very helpful, but they will not be really meaningful if we don't really have strong and powerful oversight bodies. And by that, I mean ex ante authorization and an oversight body that really has the resources to look into these surveillance programs and make an independent assessment of that. And that's why also the G10 Commission in Germany is interesting, because it has the power to stop surveillance programs or not to authorize them. And so as we look at this debate across Europe, and also the standards that are being set on the European level, we will push the German government strong to empower the G10 Commission and to give it the resources to do the things that some of it already has on paper, but it's not, in our view, not sufficient. And so the safe harbor debate, again, is really important for the reform debate that is happening now in Germany too, because we can see, on the European level, what kind of norms we have, and we have so much more transparency and information out there now what happens in other countries. And I will just want to close with saying that what was pointing out that the old times, that these discussions about how the intelligence services works and what they do, that they were just done by a very small circle in secret, these days are over. And I think the safe harbor decision really shows that. And even there will be some sort of announcement on Monday and Tuesday, but the debate will not be over. This debate will continue. 702 is sunsetting, so there will be a debate on the US side. In Germany, we will have a debate on our own reform proposal. We have the debate in the UK. There will be lawsuits probably brought. There are cases moving up in Strasburg, and the EU jurisprudence will develop further. So, rather than seeing Monday or Tuesday as an endpoint in this debate, I much more see it as a starting point for the years ahead as we continue this debate. Thank you.
Thanks, Stefan, for clarifying that this case has also in a European perspective, and I think it's good to see that it started at least in one country to discuss these kind of issues at national level, and I also believe that the European perspective should not be underestimated in France. Maybe it will, so we will hear a lot about that.
Well, the debate is certainly not over in France. It's almost just starting, I would say. Well, first, as I will restate that the objective is obviously not some anti-Americanism. It's really the challenge to challenge disproportionate surveillance. And that's exactly what we're trying to do in France. So I'm a member of French Data Network, which is a non-for-profit ISP. And together with La Quadrature du Net, we started to challenge several French acts since December 2014. I will just give a brief overview of the French data retention and data access regimes. What's interesting to note is that these regimes go as far as 2001 and 2004, when Parliament passed 2 laws mandating several kinds of data retention on electronic communications and online generated content. And so these laws predate the 2006 directive. And so for us, the decisions from the Court of Justice is a very important decision. It's a very clear message sent by the European judge on the basis of the Charter of Fundamental Rights. And what we're trying to do is to apply these decisions to make these implications clear to the French state and the French court so that the French laws go back into compliance with human rights. However, so far it's mainly a failure. There are several reasons for this. First, the first issue is that in the internal laws that we have, if we only look at the French Constitution, we have 2 decisions from 2015 which clearly shows a complete lack of equivalence between the rights protected under the Charter of the European Union and the rights protected under the French Constitution. I'll just give you an example. In one of our challenges, we sent a question to the Constitutional Council of France, and the question was very simple. Data access provisions in France had no exceptions whatsoever for attorneys' privilege, protecting conversations of clients with attorneys, and protecting sources of journalists. There was no exception whatsoever. And so the question was, is this okay under the French Constitution to not have any protection whatsoever for this kind of special cases? We know from the European Union, the Court of Justice of the EU decisions that a law which has no exception for these special cases is not proportionate. However, the French Constitutional Council had nothing to say against this and says that the French Constitution does not protect specifically these cases, even though they are very important for the rule of law and for democracy. The other problem that we have now is that this is why the European Union law is so important for us in France, because without European Union protection, we are completely out of protection from the constitutional side, which is not the same in other European countries where the constitution is more robust and more protective. So the second issue is that the French state aims at saying that all these measures are national security measures, and as such, they think that they can make a derogation from European Union law and say that the European Union Court of Justice decisions do not apply to them. This is exactly the comment that we are getting from the French government and also from the rapporteur of the Conseil d'État right now in one of our challenges. And so this makes obviously things very difficult because France is going in a completely different direction than the rest of Europe. For instance, there is a current question sent by a UK judge exactly on data access and how it could be conformed to European Union law. On the other end, there is also a question from Stockholm. But in France, we are struggling to get the Conseil d'État to follow its obligations and ask the question to the European Court of Justice. And so most probably we will not get there. And this is very problematic because if we look at the French law that results from the 2015 Act, because there was a new Intelligence Service Act passed. And if I could just show the slide that... yeah. So this is completely new from December 2015. This is the implication of Schrems and Digital Rights Ireland according to the French government. This is the list of intelligence services that have access to all intelligence techniques that are now in the law. And all of these services have access to data without any kind of judiciary oversight whatsoever. The only kind of judge oversight there is from the Conseil d'État. It's only ex post. It's not. It doesn't start at the beginning of the technique. It's only when everything is already done and the harm is done. And it's in a completely exceptional procedure, derogatory of adversarial principles. So very little oversight. And this is the list of services, which is quite broad, as you can see, and it can go longer because all that we need to expand this list is a new act from the government. We don't need any new law from the parliament to expand that list. What's also interesting is that the scope of persons and the scope of data that are concerned in the French regimes of data retention and data access is larger since 2015. Just to give a quick example, the data retention obligations do not only apply to operators of electronic communications, but they also apply to any kind of hosting providers where user-generated content is concerned. Another thing is that the objectives for which retention is justified are very large. It's basically any kind of investigation, any kind of repression, any kind of judicial or law enforcement objective. Whereas for the data use and data access objectives, it's actually very much larger than purely national security matters because they can be justified, for instance, by protecting major economic objectives of the state, which in my opinion is not strictly national security. So the implications of Schrems is very important because building on the data retention directive decision from 2014, we have the court saying that objectives justifying data access and data use have to be precise and strictly restrictive. And that's absolutely not the case in France. And so we are trying to apply this from the decision from the Court of Justice, but so far it's a very difficult fight.
I'd like to continue directly from here and relate to something what Hugo just said. France indeed is a very special case now that France has resorted to a declaration of a state of emergency and formal notification under human rights treaties of derogations from human rights. This is totally exceptional. I mean, when you look into the past, there are very few countries in the world who ever have derogated from human rights treaties because of terrorism. Peru, Algeria, Russia, UK in relation to one specific issue, time of detention before presenting the charges. But France has a sweeping, all-encompassing derogation which exceptionally relates also to privacy. And that, of course, changes the landscape of how human rights law applies and enhances the importance of EU law, because in the same way you do not declare a state of emergency in relation to EU law, you try to escape it in other ways by invoking national security.
Yeah, exactly. So if you look at the state of emergency and state of law right now, because we have this exceptional derogatory situation from the European Convention of Human Rights, we are basically left with the French Constitution. And as we can see from the recent decisions from the Constitutional Council, it doesn't grant basic protection, for instance, of client privilege with attorneys or protection of sources with journalists. So that's a big problem in my opinion. I don't know of many countries where you can find yourself in a time where the government and intelligence services can access communications data of attorneys without any kind of judicial oversight. I think it's a very problematic situation for me, and other fields of law are moving into that direction, whereas it's censorship issues. There's another challenge that we started, also trying to use European Union law, but it's also a tough fight. So this direction is very worrisome, and well, the political landscape is not really addressing that problem of lack of protection of rights.
This escape from EU law with reference to national security relates also to what Sarah said. And I think a case in point here is that now that the European Parliament is considering the new directive to replace the framework decision on counter-terrorism measures, it's also expanded to cover issues such as foreign terrorist fighters, which means not only travel abroad, but also returning and receipt of training for the purposes of engaging in terrorism. So much of what is done in the name of preventing terrorism through surveillance will fall under EU law because it's in the implementation of the new Directive against terrorism. So states will not be able to escape the scope of EU law, even under national security, when it's an issue of terrorism prevention. Anybody else on the panel wants to pick up here? Max? Franziska.
Yeah, maybe just briefly. I think that also there's a kind of mutual recognition between the principles that the European Court of Justice developed in the Schrems case. When we look at the new cases from the European Court of Human Rights, when we look at Sakharov and the Hungarian case, I think they referred mutually to each other and they refer to the Schrems case. And I think that's quite, from an EU law point of view, it's a quite important development, so that not only the European Court of Justice refers to the cases in Strasburg, but vice versa. And I think it's a good way to develop these kind of principles applying also in this framework of national security. I think it's a way forward to do that, to have these kind of common principles, EU principles, which apply in EU and in Strasbourg, in the EU and in Strasbourg. Max, maybe you can add something to that and to the also to the developments in the national countries regarding your decision.
I just have like really something short to add. I think the really interesting question is going to be, is Strasbourg picking up this whole thing? And it did. That was also initially when we crafted. I mean, Franziska was on the team for the case. Well, we crafted it because we hope it's going to spill over to Strasbourg some way to get it usable in Europe as well. I think that's something we have to work on. The other question is really what you pointed out already, is if we can find other elements where we can make sure that there is jurisdiction by the European Union to not let them escape. And that's going to be interesting how the court reacts. For example, there is Article 13, I think, in the directive saying, you know, the directive can be limited whenever there's national security thing. There is the exception in the scope at the beginning. It would be interesting cases to bring here. It's not such an easy win as probably the transfer thing. But it would be interesting if the court is willing to go a little further and say, you know, actually we do have jurisdiction here and what you're doing is not okay. And I hope that these cases are coming up. I mean, I hope that what we did is just a starting point that that's going to be utilized by many people for getting things done. There were a couple of other points, but I think we're at another issue right now.
Sure, I just had something to add to your point about the European Court of Human Rights citing Digital Rights Ireland and Schrems. And one thing I want to note is that one of the really interesting things about the Safe Harbor judgment to me was that I don't think the CJEU cited the European Court of Human Rights as it had done. It did do that in Digital Rights Ireland. And so to those out there who think that the Court of Justice of the EU got it wrong factually about the US programs in the Safe Harbor judgment. First of all, I don't think they meaningfully did. Secondly, if they did, it wasn't essential to the holding. And third, I think we're seeing a court, the Court of Justice of the EU, that is not going to back down, no matter what Strasbourg does. And I think that the fact that they relied only on their own case law in the Safe Harbor judgment helps to show that no matter what Strasbourg might or might not do, this court is forging ahead. And I think that I would also say, the court that gave us Digital Rights Ireland, Costeja, and now Safe Harbor does not look to me like a court that's going to start backing away from the principles that it's articulated.
Can I just jump into that especially? There's this whole debate about the factual finding, and I think it's important to highlight. You were talking about the intrusion and the access, and kind of where's the point where things kick in. And it was something we always had in the backhand, we just never really had to argue it actually, is that Article 8 of the Charter refers to processing, which is defined in Article 2 of the Directive. We only had to prove that they make data available. That's like the lowest level we have to kind of where it kicks in. And we weren't really we didn't really have to argue that, but that's kind of the level where we already have protection. So the factual, is my data actually used by the NSA question, which is oftentimes posted, was never anything we had to address anyways because the scope of Article 8 is so broad. And that's also in line with the Digital Rights Ireland judgment because there the storage was already the issue. Kind of making it available is the next step in the processing, like towards the government. So this is kind of in line as well because they didn't go further than in Digital Rights Ireland. So I think that's exactly the point, that the whole factual question is politically very interesting, I think. But for the judgment itself, absolutely irrelevant. And that's what also kind of the way we crafted it. That was the reason why we didn't worry about the factual things too much, honestly.
When we speak about the comparison between the two big European courts, I think it's important to note that the European Court of Human Rights has referred to the essence of a human right on several occasions, but not under Article 8 privacy. So they have kept it in reserve, at least for the time being, and that suggests that at least so far, everything is a matter of proportionality assessment. In the end, you look, is the intrusion proportionate towards a legitimate aim, for instance, protection of national security, and then you end up in a kind of balancing situation with a new name, proportionality. While if you go the essence route, you would say that there's a red line that cannot be crossed, that you don't need to do even that comparison. I don't see a reason why the European Court of Human Rights would exclude ever getting to the essence of the right under Article 8, because they have done it under other rights, but so far they have stayed away from that, whereas the European Court of Justice has courageously in Max Schrems drawn that line by saying that it was an intrusion into the essence because of being about content data.
When we read that line, we were like jumping around in the courtroom back then. It was like, we hit the essence, we hit the essence.
It also goes back to the distinction that you raised between content and metadata, which I think, you know, I mean, if we look at metadata, it's so useful for surveillance purposes because it's all structured. It's all, whereas content is, you know, it's writings most of the time, or I mean, it can be writings. It's not always structured. It's a mess to analyze. Whereas the metadata is, by definition, structured, etc. So I guess it enables surveillance in other ways, and it's a bit annoying that they referred in Schrems only to the content of communications, because in Digital Rights Ireland, they had so much about saying access to metadata is so pervasive. It's giving so many details on people's social networks, people relations, etc., that it should be taken very, very seriously. So maybe it's for the next decision, but that's a distinction that I think we still need to address, especially in other courts. This is a distinction that the French Constitutional Council has absolutely not understood so far. For instance, in the new 2015 law on intelligence services, they give a distinction between how many years intelligence services can keep data they have access to, whereas for content it's only up to a month or something. For data, it can go as far as 6 years.
I would like to briefly, towards the end of my comments, come back to the very interesting points that Martin raised at the beginning when he summed up key elements of the court decision, because I think those are at the heart of the German reform debate at the moment too. And I think, and I do hope that the German government cares in enacting a reform that would hold up in a European court. And of course, there's the German security agencies are making similar arguments that we have heard from Sarah and that are made on the US side, regarding where the intrusion starts. This is also a debate that's currently happening in the Inquiry Committee, where they also claim or argue, and they have done that in court too, that the intrusion, the privacy intrusion, really starts, when data is selected out and further processed. So that's definitely in the debate. Also, there's been lots of discussion on the content metadata distinction, because metadata does have, as personal data, has data protection in Germany, and the German security agencies have not at all given any protection to metadata, and feel like they can process and do with it, what they feel like without restrictions. So that's an important discussion that's happening in Germany as well. And the final point I really wanted to make from the list was, again, the ex-ante oversight. I think that's really, really crucial, because I think it also helps when we think about the effectiveness of the security. We want that security agencies make a case why they want to do a certain program and why they want to target certain people. And that can only happen if they kind of have to apply for an authorization. And that's documented and then can also be later reviewed by the authorizing body. And so I think that's really where we are worried about whether the German reform will meet that mark that we are hoping that actually what we have in the G10 will actually be expanded and be made more meaningful by having all applications go through that body, by having it better document its decision. And already the G10 has the power to look at ongoing programs and reevaluate them. But really the ex-ante authorization is really crucial to make sure right from the beginning that only programs are authorized that are actually serving the purpose they are supposed to serve.
I have just a 2-second follow-up to one very small element of what's been said over the past couple comments, which is when does the interference arise? And I would just remind us all that under the European Court of Human Rights jurisprudence, it's not even just with what the NSA would call the acquisition of the data. It's as soon as you have legislation allowing secret surveillance. It's an interference with the right, which I've always thought is both remarkable and remarkably perceptive due to the chilling effect that it has on your privacy and also on your free expression rights.
Thanks. I think we will now open up the floor for the public, because I think there will be questions. It's a very interesting topic. So if there are questions, please raise your hand. Yeah.
Hi, Andrew Adams, Major University. The issue of whether these various cases, the Schrems case and Digital Rights Island, are applicable in areas where the national security exemption is being stated. I think that there's some interesting stuff here following on from Digital Rights Island, where various countries either had primary legislation which didn't depend on a transposition of the directive into national law. It was a piece of national legislation doing so. Or in the UK's case, where they passed replacement legislation for the secondary legislation which transposed the directive. Now, of course, we've got challenges to those, which are saying, well, you know, the European Court judged that these were disproportionate coming out of Europe. Why does it make it proportionate when they are then applied in national law? Because you're not simply saying that these are purely for national security purposes. The same argument you talked about with the new draft Investigatory Powers Act in the UK, that basically these are not simply national security only, and they're only used for national security, and there are very strict limitations on that. The data retention legislation in various countries does not restrict the usage of that retained data. And the court clearly said that this blanket, based on other judgments as well, like Sabam, blanket retention is definitely not proportional. So I think we may have a window when those cases that are pending in the UK and I believe Poland at least, against this either primary existing legislation or replacement legislation come through and hopefully get referred to the ECJ, we may see. And I wonder if anyone on the panel has comments about where they think that's likely to go.
So, since the 2006 directive has been declared invalid by the court, we now have the directive 2002/58 as a fallback, right? And this directive says that communications operators should anonymize the data once the communications is done and this data is not needed anymore. If you look at Article 15 of that directive, it's a very interesting article because it says that member states have some margin to take national security measures that could be exceptional in light of the obligations to anonymize the data. And as an example, it says maybe you could also have data retention laws, but the Article 15 says you can have these laws for national security measures if they are still proportionate with the Charter of Fundamental Rights of the European Union. So even on the basis of national security, the directive is very clear. But it didn't stop the French government from claiming that because it's a derogatory procedure from, it's a derogation from the main obligations, they still think that the Charter should not apply, even though it's clearly against what is stated in Article 15 of Directive 2002/58.
I will add a small comment, which is that, of course, the decision in Digital Rights Ireland is difficult in the sense that the finding is kind of an omnibus finding. There were so many things that were wrong with the legal framework of the directive. And one way to read it is that the EU, if it wants to regulate the issue of data retention, it must regulate it fully. What's a serious crime? What is the mechanism of judicial oversight, etc.? And you can't have it halfway between the nation state and the EU. Now that that is replaced by national laws on data retention, those questions need to be addressed, but at least it's a safe way to go through the bulk access or mass surveillance and say this is always disproportionate. That's a safe ground to say that it doesn't work even then.
And sorry, just one, I mean, we have a case in front of the ECJ right now, which is the Swedish case, which exactly asked this question: is blanket retention in line with European fundamental rights? So there is a case in front of the ECJ answering this question.
And as far as I know, the UK case is coming up as well. I think this question is going to be interesting. It's going to be mainly a jurisdictional question, not a material law question. I think I mean, there are these issues, but still. The other thing is we will have a lot of these ping-ponging. We are now just having the PNR debate, and I was in the parliament when there, a couple of members of parliament debated that, and were like, yeah, we are under the political pressure to pass something after Paris, knowing that this is total bullshit what we're doing. And one was walking up to me, is like, I'm going to say yes, but I hope that someone like you is coming around and killing it again, which is, asking the question what our politicians are up to. But we're going to have 100 cases like these very likely coming up sooner or later, and I hope, the direction from the courts is going the right way.
Any other question? Yes.
So what happens at the point that perhaps we've got very high standards set by the CJEU, which perhaps is saying that in certain circumstances it's prepared to tell national governments that they can't do some of these practices? What happens at the point that France, the UK, Hungary perhaps, Poland perhaps, say, well, actually, we don't really much care about what the CJEU is saying in this point? There seems to be a lot of political alternatives for how this goes. And it seems to me that ultimately some of this has to be political. Some of this has to be about what we as citizens want from Europe and our courts. But it seems quite an intense political battle at the end of the day. And I'd like to hear the panel's views on how that might play out.
I can take a start. Unfortunately, so I am not particularly knowledgeable in enforcement mechanisms in either the EU or the Council of Europe, but what I can observe is that to the best of my knowledge, the UK, as fractious of a relationship as it has with those institutions, to the best of my knowledge, there are very, very few European Court of Human Rights judgments that it has refused to implement. Prisoners' voting rights is the only one I can think of, and I think even then there have been some sort of gestures toward it. So even very controversial judgments that succeeding governments have really not liked, I think the historic tendency has been to implement them. So for what that's worth, I would just make that observation.
Yeah, it's a very important principle of rule of law that when the courts decide, even when they are European courts, then the political organs back up the decisions and enforce them. If governments and peoples in European countries then are unhappy with the judicial decisions, there are processes to amend the foundational texts. Don't forget that the UK was unhappy with the European Convention on Human Rights. They convened the Council of Europe member states to Brighton and adopted a Brighton Declaration. It has become a protocol to the European Convention, so that the notion of marginal appreciation is on its way to the official text of the European Convention on Human Rights. I don't think that stops the court, but it is a way how governments may react, and they have a right to do so if they get sufficient support to amend the treaties. Often not.
Just like my 2 cents probably in the end. I mean, we have this overall issue right now. I mean, look at Schengen. I grew up in Salzburg and we can't cross the border anymore. And we have this fact a lot of member states are just, you know, the whole situation of the European Union overall. So I think it's dramatically interesting to see if this kind of, if a court goes too far, it adds to the heat in a way. And, but this is, you know, a bigger political thing than probably this panel can answer in a way. But on the other hand, that the majority of people is unhappy in a fundamental rights case is oftentimes the case, because I mean that's what fundamental rights are there for, is if the majority voted for something or the representative of them did something wrong, that, you know, we can still do something about it. So I think that's the elements that play in the field, but it's interesting because we see a lot of member states just saying, you know, whatever. We're just going to go ahead and block the roads or whatever they're doing, you know.
Maybe I'll just say one more thing. Sorry, and I should be clear, the person who asked this question knows a lot more about the UK situation than I do, and is in fact an expert. But I would also add that this helps to show that litigation, I think, is one of the most important tools of change that we have, but it's certainly not the only tool, that we also need to, at the same time, be pursuing domestic legal reforms, such that even if worse comes to worse, and the UK decides to, you know, cancel the Human Rights Act and all of this, that we can still maybe get some domestic reforms.
Just by way of a follow-up to that question, perhaps do we also have a slightly different issue, which is to what extent do we see cooperation between national courts on this issue? And in the run-up to the Digital Rights Ireland challenge, one of the things that I think emboldened the court, even prior to Snowden revelations, was the fact that there had been a consensus in other jurisdictions already striking down national data retention laws on other grounds. And then post-DRI, of course, we've seen that with the various national judgments implementing DRI. So traditionally, the Court of Justice, in a wider European law sense, hasn't relied on an authoritarian imposition of its views on national courts. It's seen itself as operating in partnership with national courts to ensure the application of European law. And I'm wondering to what extent is that now going to happen in the field of surveillance? Or possibly are we going to see a contrary outcome where in some jurisdictions, as has been discussed already in France, national courts simply can't be seized of these issues in a way which allows people to raise them, and therefore we end up by default having to take them up in Luxembourg or in Strasburg because we can't get the national courts to that point.
So, okay, maybe we can have one final question if you have a question. Otherwise, we wrap up with the final statement of each of the speakers. If we don't have a question, we can't see it actually, but we will. Okay, so Max, your final words.
Oh, my final words, there aren't too many. I mean, it's going to be interesting what comes down. It's going to be interesting what we see on Monday and how this whole thing develops. I think we had a nice overview of what the issues are, and TJ just pointed out also this kind of question of how the member states are going to react to it. I had the feeling with after Digital Rights Ireland and Austria, I mean, our court was very determined to kill data retention. They kind of, you know, waited for the agreement from Luxembourg. But other courts were probably then feeling braver and felt that they can actually do things. And in the end, these fundamental rights decisions are political decisions to a large extent. You can turn these cases either way. In my case, in Luxembourg, it was obvious that the courts, the judges just wanted to trash the commission like crazy. I mean, this was a tribunal in the way of the commission. We were sitting there and we're like really giggling because we hardly got a question. But this is oftentimes, how things spin in the end, and I think that's going to be interesting to see how the overall development is going to be.
Yeah, I think the debate is ongoing at the Court of Justice, and I have to thank the efforts of Max and other associations and organizations who litigate those cases and try to make national courts enforce privacy rights and data protection and other fundamental rights. because inside a national context, especially with such strange historic times in countries such as France, it's all the more needed, I think.
Well, this panel turned towards big political issues of power. And of course, it's one scenario that leading courts of nation states, such as constitutional courts in Hungary and Poland, become platforms for political struggle. And there are powers that seek to get control over their courts. And then it's, of course, time for European courts to step up and fill the vacuum and stick to the principle. And there, I think, issues such as what we have covered, proportionality, essence of privacy, distinction between content metadata, levels of intrusion, they are important to keep in the debate because they allow for a structured and rational process of decision making, be it politicians or be it judges. There is a conceptual toolkit which can be used to demystify the issues, and I think it's very important in issues such as surveillance versus privacy to avoid the abstract overall choice between the two and to have a structured frame for decision, and then we need the conceptual tools for that.
Yeah, I would just like to really briefly just reiterate that the issue is obviously not going away, and I think we have to think also carefully about how litigation and advocacy can have developed strong synergies. I do share the concern that you can't just leave it to the courts. They need to be, you need to get engaged also on the national level with the parliaments and have the discussions there with the policies, but obviously the courts help in those debates. You know, they point out important norms and standards that have to be met and put into policy, but we can't just leave it to the courts because that, you know, other examples show that in the end leads to backlash against the courts. We have to flank that kind of work with directly talking to parliaments and also educating the public about this issue.
I hadn't really thought of any particularly great concluding thoughts, but I will say, I think from my own perspective, I don't know that there's really ever anything new under the sun, in the sense that, yes, both Europe and North America are facing threats of public violence as they perhaps always have and always will. And let's think about whether these measures really are strictly necessary to be countering the kinds of threats that we have always faced. Thank you.
Okay, thank you all for coming, and a round of applause for the speaker.